Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Izra Imran bin Azali. And before we move further, before we converse into the topic of into the discussion, the application of this case, the specific case of Miss Anna and also Mr. George, I would like to highlight first about the general concept about this psychiatric claim. And of course, when it comes to psychiatric claim, it is involving negligence. Negligence is very, very essential in the law of thoughts, in the field of law of thought, as it has to be deal with many elements, and of course the three main elements, which is the duty of care, breach of duty of care, and then the damage is not too remote. And of course, when it comes to the psychiatric claim, especially because it is a non-physical claim, it has to deal with many sort of detailed analyzation of each element. For example, after how can we determine someone have the duty of care, and then we have the Caparo test to determine the proximity, the possibility elements in order for someone that breached their duty, whether they already foreseen it, whether how about the proximity to the victim. And we have to consider everything when it comes to the law of thought, and especially to the psychiatric claim. And so I would like to highlight the word from Lord Wilberforce, but just the quote, I will just read it. But this discounts accepted, there remains, in my opinion, just because short in its nature is capable of affecting so wide range of people, a real need for the law to place some limitation to the extent of admissible claims. So we will converse in more about this. Okay, the general rules of this psychiatric claim. Okay, psychiatric claim is also known as the nervous shock, and it is the non-physical damage that's suffered by the plaintiff. And the concept of proximity and possibility is everything when it comes to determining whether the plaintiff claims is valid or not. Assalamualaikum warahmatullahi wabarakatuh. So for our first case, which is the leading case with regards of the claim of psychiatric claim, it is Alcott and others and Chief Constable of the Yorkshire Police. Basically what happened in this case, a brief fact of the case. What happened in this case is basically there's a tragedy occurred in the stadium, which caused by the negligence of the police, and the claimant of this case is the victim, not the primary victim of this the tragedy at the stadium, but the secondary victim, which the one that suffer psychiatric illness, or we call as nervous shock, because of what they saw happening in the stadium. But unfortunately their claim is failed because the court distinguished between the primary and of course the secondary victim, and they are the secondary victim. Unfortunately, the elements of requirement to fulfill to be fulfilled in order for them to claim for psychiatric claim is not there. It is not enough for them to claim because the most important because the elements of proximity is not enough. They are not there in the actual place that the tragedy occurred. They watched it from the television.
Hi, Assalamualaikum. I'm Izwan, and let's continue with the second case law, which is Page against Smith in 1996. In this case, the plaintiff, Mr. Page, was involved in a minor car accident and was physically unhurt in that time. However, the crash did result in a recurrence of chronic fatigue syndrome or ME, from which he had suffered for 20 years, but was then in remission. The defendant admitted that he had been negligent, but said he was not liable for psychiatric damage as it was unforeseeable and therefore not recoverable as a hit of damage. So the court provided that some kind of personal injury was foreseeable. It did not matter whether injury was physical or psychiatric. There was thus no need to establish that psychiatric injury was foreseeable. Therefore, the defendant was liable in full for the claimant's psychiatric harm.
Moving on to the next case law, the case of McFarlane versus CALEDONIA. Okay, the fact of the case is the claimant had witnessed a tragic event at an oil rig which is caught on fire and caused him to have psychiatric illness, and he tried to claim for that from the defendant. However, the holding was in favor of the defendant, as it is said that the defendant is not liable for the plaintiff claim, as the plaintiff itself was not in the zone of physical danger at the moment of the tragic event occurred. This is because he was in a boat far away from the oil rig. So, based on the decided case of Alcock versus Chief Constable of South Yorkshire, it is said that this claimant, is a secondary victim and is not a primary victim. So, three elements need to be fulfilled in order to claim for psychiatric illness, and the third one, which is the sufficient close relationship between the secondary victim and the primary victim, is not established, as the claimant did not even know, did not have a sufficient relationship to the workers at the oil rig. So it is not, the third element is not fulfilled, thus the claim is failed.
Hello madam, I'm Angela here. I would like to present on the case of Bourhill against Young, where the fact said that a motorcyclist was going too fast into a car and was killed. Miss Bourhill, who was 8 months pregnant, was about 50 yards away. She heard the accident but did not see it. Afterwards, she saw blood on the road and suffered shock. Her baby was stillborn as a result. Health, the judge said that cyclist did not owe a duty of care, as he could not have reasonably foreseen that she will be affected by his negligent driving, and she was not sufficiently proximate enough to the damage.
Okay, next we will go to the analysis or the application for the case. Firstly, we need to question the duty of care, whether the defendant owed the duty of care to the claimant. So, we proved that Timberland Company owed a duty of care to their workers, which is you guys, and also it has been proved that the breach of duty and the damage are not too remote from the company, and also the time, as you guys were going back from home from working. So, firstly, I want to point out for Mrs. Anna case. Firstly, you directly saw the tragic event which have caused you to suffer psychiatric illness, and also Mr. John to die in that event. And not only that, it also occurred to you physically, as heavy sheets of wood fell on you and laid Mr. John. So you are not a secondary victim in this case based on Alcott versus Constable Chief of South Yorkshire. You're the primary victim. And according to the facts, negligence on behalf of Timberland's company itself led to this tragic event. And yes, I would advise you to claim for this psychiatric illness.
In the circumstance, we managed to see that Timberland owed the duty of care to Miss Anna, and the late Mr. John and Timberland had breached said duty that caused both of you to suffer such tragic damage. But we will focus on Miss Anna here. It says after that event you have been diagnosed with post-traumatic disorder (PTSD), and this is where we will look if you are capable to psychiatric illness claim.
Firstly, we must look back on the case of McLaughlin against O'Brien. In this case, the question of proximity is everything. I'd love to include the word by Lord Wilberforce, but this discounts accepted there remains. In my opinion, just because shock in its nature is capable of affecting so wide a range of people, a real need for the law to place some limitations on the extent of admissible claims. It is necessary to consider three elements inherent in any claim: the class of persons whose claim should be recognized, the proximity of such person to the accident, and the means by which the shock is caused. In terms of proximity, nothing we have to say, as Miss Anna was there when the accident happened.
Assalamualaikum warahmatullahi wabarakatuh. So basically, Miss Anna was there when the tragedy occurred, and according to Lord Oliver in the case of Yorkshire Police and the Alcott one, basically according to the case, the one that participate in that event, the one that is there during the events happen, the one that was there when the tragedy occurred is considered as primary victim. So no matter what, we can conclude that Miss Anna is our primary victim, and if this statement is not strong enough, I'll take the case. I'll take the statement from the case of Pagey and Smith, where even though the claimant was not physically injured, the incident triggered his ME, or we call as myalgic encephalomyelitis, and once again, in that case, in the case of Pagey and Smith, the claimant doesn't have anything to do with the physical injury of himself, but it directly, even though he's a primary victim and doesn't even injured in physical contacts, but this injury of psychiatric injury, psychological injury is enough for him to be this primary victim. And if this case is not good enough, I take another case, also the case of which where they Dan had already mentioned about this case, which is the MCFARLANE and CALEDONIA, in which the claimant failed on its claim because the court stated that the claimant is not there when the tragedy occurred, or the other words, the detailed word that court stated is that the claimant is not there when the tragedy occurred. He is not in the danger zone when the tragedy happened, even though he really suffered the psychiatric illness, nervous shock, but he is not there. So it is not enough for him to be the primary victim, and because he is away from the danger zone. However, our Miss Anna here, she's really involved in that tragedy. That tragedy occurred on her.
And now we move to the complex part of this case. Mr. George, I understand your pain. I really do. In common sense, anyone would develop an anxiety disorder after witnessing such a tragic event. According to the fact here, you managed to be classed as the secondary victim. However, Mr. George, as the matter of practicality and the matter of facts determined in law for secondary victims to succeed on his claim of psychiatric illness, the word to be highlighted here is proximity. In the case of Alcock and others against Chief Constable of the South Yorkshire Police, the claimant failed on their claims of nervous shock as they are not in proximity to which they heard and saw the tragedy from their television at home, even though the victim of the tragedy is their own family members.
So, Mr. George, in the matter of claiming for psychiatric illness, the court have some ruling based on the decided case, especially the case of Alcock and others versus Chief Constable of South Yorkshire Police in this particular matter. So the court stated that the person who saw a tragic event on television could not be considered to have suffered nervous shock induced by sight or hearing of the event. This is because there were no proximity to the event and would not have suffered shock in the sense of sudden assault to the nervous system. So in order for you to understand this, so let's look into the elements for a secondary victim to succeed in claiming for psychiatric illness that have been established in the decided case of Alcock and others versus Chief Constable of South Yorkshire Police.
Good morning, madam. I'm Durkeshwari, daughter of Ravi. I would like to continue the analysis or application part. The three important elements to be fulfilled according to the case are: first, his relationship to the primary victim was sufficiently close that it was reasonably foreseeable that he might sustain nervous shock if he apprehended that the primary victim had been or might be injured. Next, his proximity to the accident in which the primary victim was involved or its immediate aftermath was sufficiently close both in the time and space. And third, he suffered nervous shock through seeing or hearing the accident or its immediate aftermath. That's all from me, madam. I would like to pass to my friend.
So Mr. George, from these three elements that needed to be fulfilled in order to succeed claiming for psychiatric illness from the Timberlands Company, in your case, only two elements has been fulfilled. The first element, however, is not fulfilled, as the relationship to the primary victim that needed to be sufficiently close that it was foreseeable that you might sustain nervous shock as a secondary victim is not fulfilled, because in this case, in this tragic event, the primary victim of this event is Miss Anna and Mr. John, and late Mr. John, and you don't even know them. So it is not sufficient for you to have close relationship that is foreseeable that you might sustain nervous shock as a secondary victim. This ruling is taken from the judgment in the case of Alcock versus Chief Constable of South Yorkshire Police from the Lord Oliver, and I quote, "It followed that none of the appellant was entitled to succeed because either they were not at the match, had seen the disaster on the television, or heard on the radio, which is not your element, or their relationship to the victim had not been shown to be sufficiently close to enable them to recover, which is in your case. This is the element that you are not fulfilling in this case. So the appellants would therefore be dismissed."
In analysis, basically, Mr. George, not just in terms of proximity but also in terms of possibility, is not fulfilled to success in this psychiatric illness claim, as we look into the old approach of the secondary victim, which in the case of Bourhill against Young, where Miss Bourhill failed on a claim of psychiatric illness, even though the fact that she came to the place of tragedy where the late Mr. Young died. In the fact, it is not something that is possible for the late Mr. Young to foresee that his negligent act will go to the extent of causing the psychiatric illness to everyone. The same goes to what happened in Mr. George case, where negligence on behalf of Timberland's company occurred only to its worker, as Timberland will never foresee the circumstance of its negligence will harm someone that walked past out of nowhere.
I love to include the word from Rod Hustle of Kilowatt has between John Young and the driver of the motor car. John Young was admitted negligent in that he was a bunch of duty which he owed to him of not driving while passing the stationary tram car at such a speed as could prevent him from pulling up in time to avoid a collision with any vehicle which might come across the front of the tram car from Colinton Road into Lockhart Road, but it might no means follow that John Young owed any duty to the person. That facts relevant to this question seems to him to be this. This person was not in any physical involved in collision. This is what happened in your case, Mr. George, and in law this is where we will call mere bystander.
I'd like to talk about the conclusion part. By this, I shall conclude that Miss Anna, justice shall prevail upon you, and by God's grace, you will succeed on this claim as you are the primary victim, and even though you suffered none of physical injury, just like what happens in the case of Page and Smith, and also the case of McFarlane and E.E. Caledonia, where you are in the zone of physical danger. Unfortunately for Mr. Josh, after making such detailed analysis according to the fact and previous cases, it's impossible for you to succeed on this claim because you are not the primary victim. And even as the secondary victim, you didn't fulfill the requirement to claim and which we call as the bystander, as according to the fact and judgment laid in the case of Bourhill and Young. That's all from me, madam. Thank you.